Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis.
Start. Learned counsel appearing for the respondent understandably supported the finding of the Labour Court in regard to the evidentiary value of the receipt produced by the management. He further contended that the High Court was justified in enhancing the back wages to 100% since the material produced by the appellant for the first time in the writ court showing that the respondent workman was gainfully employed could not have been accepted in evidence or relied upon for denying the workman his legitimate right to claim full back wages. He also submitted the said evidence was not reliable and in fact the workman was not gainfully employed. Having heard the learned counsel for the parties and having perused the records, we notice that the factum that the workman was in the service of the management till 22nd of April 1993 is not disputed. While the workman contends that his services from that day were wrongfully terminated, the appellant contends that the workman voluntarily left the services of the appellant, having taken all his dues. Since the respondent workman was in the service of the appellant management at least up to the 22nd of the April 1993, the burden of proving that he voluntarily left the services then falls on appellant management. This is satisfied by the oral evidence adduced by the management and the documentary evidence produced in the form of the receipt purportedly executed by the workman and the entries in the bonus register. The Labour Court, considering the said document, which is said to be a receipt executed by the respondent, noticed the fact that the original of this document was never produced by the appellant and what was produced was only a photocopy. Even this photocopy was not confronted to the workman when he was in the witness box, and the signature found in the said photocopy, as also in the photocopy of the bonus register, shows that though two documents came into existence simultaneously, the ink with which the respondent workman is supposed to have signed the two documents was different. In such circumstances, it held that it was not safe to rely upon the said document to accept the case of the appellant. The High Court in this regard held that though it may not be necessary to apply the strict rule of evidence in regard to production and proof of a document, still the workman ought to have been provided with an opportunity to explain his version as to the alleged receipt having been executed by him, and such opportunity not having been offered by confronting the document to the workman, the appellant in effect has violated the principles of natural justice, and hence by its act of default the workman's case cannot be prejudiced. However, as stated above, Shri Lalit, learned senior counsel, contended that the workman was aware of the contents of the document because he had the photocopy of the document served on him, based on which he had cross-examined the management witness.